The Judiciary convened the 27th Annual Judges Conference on the theme Judicial Wellness, a tool for effective case management. President Yoweri Kaguta Museveni was represented by the Vice President, Major Jessica Alupo, who emphasized wellness and good health among judicial officers.
One of our central tasks was to restore authority, discipline, and respect for the law. That work must be sustained. Our people should experience justice not in legal theory, but in time taken to resolve disputes, the cost involved, and the certainty of outcomes. When cases delay, citizens lose confidence, investors hesitate, and social tensions rise. Justice delayed is therefore justice denied. That is why I have consistently emphasized speed, efficiency, and discipline across all state institutions, including the judiciary. Let us be honest. Backlogs are not caused by laws alone. They arise from systems, organizations, leadership, and human capacity. Judges are human beings. They carry heavy workloads, face public pressure, and handle emotionally demanding matters. Judicial wellness is therefore not a peripheral concern. A healthy, organized, and well-led judiciary is a productive judiciary, one that clears cases faster, manages pressure better, and delivers predictable justice.
With a stunning case backlog of over 16,000 cases, President Museveni reiterated speeded disposal of cases and maintaining an independent and a strong judiciary.
Our people should experience justice not in legal theory, but in time taken to resolve disputes, the cost involved, and the certainty of outcomes. Justice must therefore be accessible, timely, impartial, and respectful. I wish to remind you that effective justice systems lie at the very heart of every democratic country.
President Museveni again called on judicial officers to fully embrace alternative dispute resolution mechanisms and modern technology as a means of dispensing justice effectively and reduce case backlog.
Backlogs are not caused by laws alone. They arise from systems, organizations, leadership, and human capacity. A strong, independent, and efficient judiciary is indispensable to democracy, peace, and national development. It underpins investor confidence, protects rights, resolves disputes, and maintains social order. This is why we continue to support judicial infrastructure expansion, staffing, training, and institutional reform, even as we demand discipline, integrity, and accountability. I wish to speak about three interconnected concepts: the Africanization of justice, the judiciary as an enabler of wealth creation, and the central theme of judicial wellness. These are not separate ideas, but different facets of the same goal.
The Judiciary latest ADR report shows that 5,000 cases were disposed of at different courts across the country in the year 2025 through alternative dispute resolution mechanisms. Chief Justice Dr. Flavian Zaija said, while service delivery remains a key obligation, it cannot be effectively achieved without healthy judicial officers.
As Chief Justice, I will ensure that we implement institutionalized support, including training on stress management, work-life balance, and where necessary, access professional and confidential help. I think in the morning, I don't remember whether it was Zemokor who said that he directed someone to Butabika, and the person said, if they see me coming from that mental hospital, they will think I'm also, the wires are off. So I think there was also this idea we had suggested when I was principal judge that we could bring like psychologists within the building. Then the people started raising an issue that you see, when the people see you going there, if the office, let's say, is on the ground floor, and then they see the Chief Justice going there, then they will start saying, it appears there are issues. So I think it's a wider discussion we need to have and find a solution. But we must have these facilities. Here at this conference venue, a medical camp composed of a team of medical workers from Murago National Referral Hospital, led by an associate consultant that has been organized for your benefit. Kindly make use of the medical camp. We have already established gym facilities accessible to all judges at the Court of Appeal and Supreme Court buildings. The same will be extended to courts in other regions. Let us all be mindful that a healthy body leads to a healthy mind. We shall also continue to lobby for resources, for improved teams.
He outlined key focus areas for the judiciary, strengthening alternative dispute resolution mechanism and capacity building for judicial officers.
We must leverage technology to ensure that we do many of the things that we have not been doing. We should have software that enable, so that the judge just speaks into the machine and the machine writes the judgment. Then specialize the case handling. We shall do a lot of training in this direction. We shall expand the ADR. I think you notice that at the Court of Appeal, for example, there used to be belief that you cannot mediate a Court of Appeal matter, but I think you saw the statistics which they have represented. Very, very, very big strides. So we are going to expand this at the Supreme Court as well, and then the rest of the courts. I think we had an ADR conference on Friday. Those of you who attended, you know what we discussed. Strengthening staff supervision, as I've mentioned, we must earn our salaries. This is going to be very critical, staff supervision. Expansion and modernization of judicial infrastructure, including construction of courts, archives, and institutional houses. Now, I emphasize institutional houses. We've been having challenges where our judicial officers are posted far away from here, and then they struggle looking for houses. I think one of the things I remember very well was when I went to a place called Kabong in Karamoja, and I found our judicial officer was staying in a police barracks. He had there a small manyata. And when he disagreed with the DPC, he was evicted.
The conference was attended by justices of Supreme Court, Court of Appeal and High Court judges, during which performance reports were presented in the conference.
We have also used virtual systems, and litigants who are outside jurisdiction or far away from the court, as well as appellants who are in prison, can use video conferencing to facilitate the hearings. This has promoted convenience and cut down on the cost of cases, cases for proceedings, for case processing for all the stakeholders. The justices too have embraced the use of video conferencing facilities to avoid adjournment in instances where a particular justice is out of the jurisdiction or for some other reason cannot be physically present in court. So court sessions have proceeded with some of the justices on the panel appearing virtually. Recently, we had training on the use of artificial intelligence in legal research and case management. And we engaged in practical, for participants engaged in physically navigating the platforms to test several features, such as demonstrating how legal tasks can move from manual processes to AI-supported workflows with verified sources and secure sessions. We will continue with the training. The court received a week-long training in the management of presidential election petitions in December 2025. And we are pleased to see our colleagues from Kenya who actually facilitated the training. Thank you very much, Justice Dr. Wanjala and Justice Isaac Lenawola for having joined us, and now you are here again to share your wisdom with us. During the training, the justices, the registrars, as well as our research magistrates all benefited from the training. We, however, learned a lesson, and this was a lesson from other jurisdictions, that such training must be conducted way before elections and must not be a one-off. So I hope that in 2031, or in preparation for the 2031 presidential election, we will start the training earlier. Now, challenges encountered. We have encountered challenges in forming quorums, especially in constitutional matters. The quorum of the Supreme Court is 5 in civil and criminal appeals and is 7 in constitutional appeals. Considering that some of their lordships at the court participated in matters at the Court of Appeal before being elevated to the Supreme Court, we can only have one quorum at a time, and it is often difficult to raise quorum, especially for constitutional appeals. We have prepared a list of cases which necessitate appointment of acting justices. The head of the court will take advantage of the law which allows for the appointment of acting justices so that we deal with these cases during this year. Another challenge we face is abuse of court processes or court process. There's a growing habit of litigants filing further appeals disguised as applications for review. Litigants hide under the slip rule embodied in the rules of the court to bring applications, and they also hide under Rule 22, the rule on inherent powers of the court, and in essence, they request the court to sit in their own cases as an appellate court. We have also dealt with a number of criminal appeals challenging severity of sentence, and yet this is barred by Section 523 of the Judiciary Act. The challenge we face is that to dismiss a matter filed in contravention of the law, we still require to sit as a full quorum of the court, and there is need to review the law. Mediation. During the 2025 annual judges meeting, we committed to introduce mediation as a strategy for expediting case disposal at the court. Since we started its implementation in May 2025, 9 cases have been registered. 6 have gone through the mediation process, but out of this, 1 has been successfully settled and 1 partially succeeded. The nature of cases which are registered for mediation are commercial disputes as well as land disputes. the mediation registry is yet to be fully operationalized.
Your Excellency, the Judicial Training Institute, acting under the direct authority and guidance of the Chief Justice, has the privilege of organizing this annual event. It brings together all serving justices and judges, our esteemed retired judicial officers, and other critical stakeholders. Your Excellency, you saw the retired CJs, the retired DCJ, the PJ, and all the retired justices. They are here with us. The conference is deliberately designed as a moment of introspection to celebrate the milestones achieved over the past year, to candidly examine the challenges we have encountered, to extract valuable lessons from both our success and our setbacks, and most importantly, to forge concrete, actionable strategies that will propel us forward in the year ahead and beyond. Your Excellency, this year we have deliberately chosen the theme Judicial Wellness, as guided by the Chief Justice and members of the top management of the Judiciary, a theme that speaks directly to the human dimensions of our noble calling. Judicial work, Your Excellency, is intellectually demanding, emotionally taxing, and often carried out under intense public scrutiny and pressure. By centering our deliberations on judicial wellness, Your Excellency, we affirm that a healthy, balanced, motivated, and supported judicial officer is better equipped to deliver fair, timely, and compassionate justice. A happy, satisfied, and resilient workforce does not merely sustain the institution, but it also elevates it, producing judges of greater wisdom, empathy, clarity, and moral courage. In turn, better judges are indispensable to meeting the ever-growing and increasing complex justice needs of our dynamic society. As the Judicial Training Institute, our foundational mandate is to serve as the engine for implementing the Chief Justice's transformation agenda for the judiciary. This is the agenda that is now firmly anchored in the Judiciary Strategic Plan and global best practices in justice administration. The agenda emphasizes the following key objectives. One is enhancing efficiency and effectiveness. The second is promoting accountability, transparency, and a robust performance management. The third is improving access to justice for all Ugandans. The fourth is accelerating digital transformation and automation. The fifth is prioritizing judicial and staff wellness and welfare, strengthening institutional capacity. My Lord CJ, you will recall,
the mental burden of discretionary deliberation and appeals. I invite all of you to join me in noting that the presentation you hear are not delivered from a distance. They are the product of your own collective effort prepared by yourselves in your assigned groups and panels. These are papers that speak directly from our lived experiences.
Emotionally, let me just look emotionally.